Okay. To talk a little bit about the disciplinary process itself and what that has involved. I think what I was saying and what my point here is that this system, this. Can you turn that off?
Air conditioner.
Yeah.
I would just leave it.
Yeah, just let it run. Oh, you can handle a million cases on your own, but you can't turn off an air conditioner? Women.
Because it's a circle. It would have been a button.
Yeah. All right. Now back to the Don Bailey disciplinary proceedings. You know, one thing that needs to be stressed here is that an attorney's law license is a property right. Under the Constitution of the United States, you're supposed to have due process before your life, liberty, or property is taken. And the bar license is a piece of property. There are protections that come with that. Notice, opportunity to respond, fair hearings, opportunity to cross-examine your accusers, and a whole host of things. None of that at all has been afforded to Don Bailey. You know, ideally, as an attorney, you'd want to look at a proceeding like this, and you'd think that this is the Pennsylvania Supreme Court running a disciplinary proceedings, hearings, evidence for lawyers. It's lawyers prosecuting, lawyers defending, lawyers sitting on the panel, lawyers making all decisions. This is lawyers for lawyers. And if there's one place in America that you think you'd go and you would find strict accordance with the rules of evidence, strict accordance with due process, you know, super scrutiny to making sure that rights were protected, you would think that it would be here. But this system has made an absolute mockery of every one of those principles. Don Bailey has not had a single witness. I mean, he's had witnesses. I testified at the hearing. I testified for a while and got as much as I could in before I was cut off by the disciplinary counsel or cut off by the hearing examiner and had my rights and been threatened or said that it's being irrelevant. You know, not in the context of any objection. There was just no order whatsoever to this proceeding. There were speaking objections from the disciplinary counsel. There were conversations between, you know, the attorney or the hearing examiner and disciplinary counsel. There was obstruction and interference the entire time. And one of the most appalling things that happened during that hearing, and Steve Conklin will tell you about it too, is Steve was testifying. Well, you got to understand, when we went into these proceedings for Don Bailey last August 11th and 12th, this was down in the Commonwealth Court. They had security dogs going through the building. They were bringing them through, sniffing around the building as if there was some, and they had 5 or 6 security guards there when the hearing started this morning. It was just the deliberate creation of such a menacing presence in and around that courtroom. It was really, you know, there are certain 3 or 4 times in my career and my life, you know, I've walked into courtrooms and I've sat and I've felt like I'm wearing oppression, like it's a hot, wet wool blanket. That was one of those days. To see all that going on, it was just really disheartening. And to know that it was a crooked and fixed proceeding where all rights were cut off. I mean, judges come in willy-nilly and testify for the disciplinary board. But when Don wanted them in his case, no, they object to the subpoenas. They send U.S. attorneys in to fight the subpoenas. They have nonsense hearings where there's no evidence, and then they quash these subpoenas. This is the type of due process that Don has gotten all along. And, you know, the reason, the entire premise of due process of law, I mean, I'm not a constitutional historian or anything. But ultimately, what the Declaration of Independence was about a check on the oppression of a government. And there's a whole host of grievances that were listed. And what experience has taught is that when people are not being afforded their rights, it's not negligence and it's not oversight. It's because their rights are being denied fundamentally. And in this case, you could not do, you know, it completely undercuts the legitimacy of the entire process when they are violating every procedural right along the way. So if you look at these proceedings, and if anybody honestly looks at them, you'll see and you'll reach the same conclusions about these violations of due process and the absolute mockery of justice. But what speaks in these repeated, extensive violations of due process rights, what the conclusion that they lead you to bring is the entire thing is illegitimate in its start. It's illegitimate in its origin, and I think that we covered before that we can prove that. This is judges in America carrying out political agendas, picking up telephones, not liking attorneys, because not just because they don't like them. I mean, there are some judges that I think are abusive enough to try to carry out strictly personal agendas against people they don't like. But this is about much, much more than that. This is about an attorney, Don Bailey, who threatens their existence because these judges and the people that they protect have not gotten to their positions strictly on merit. They have gotten to their positions by playing the game that we're all being victimized now, by doing a favor for a friend, by, you know, looking past something with a wink and a nod. And when you come across somebody, I'd like to think that professionally I'm in that category. I personally don't think that in many ways I'm fit to shine Don Bailey's shoes, but I'd like to think that when it comes time to doing what's right in the courtroom and knowing my way around the courtroom and the law, I'm every bit as fit as and capable as him or any other attorney in the world for that matter. And my ultimate point, what was my ultimate point? If you could tell me.
I have a question to ask you.
Okay, let's stop and take the question. Although I did want to finish up, I thought I had a good point there. Go ahead.
Well, my question is about the proceedings. Number one, there's different types of hearings. I'm wondering, are they open to the public? Are they videotaped? And what type of...
Well, you asked, you asked a partial question that, you know, I could probably take off and go on about 4 or 5 tangents, but one thing that has been revealed through this proceeding is that the Commonwealth of Pennsylvania is in serious trouble in terms of recording all proceedings. There was a motion filed by Don, and he, actually it was something that you know, I've looked at things, looked over things, you know, just giving my advice, input as a, you know, a friend and someone interested. But I don't know as much about this. But the way that they are conducting proceedings and what they use as official court reporters and things of that nature has been revealed as having some very serious constitutional problems. I mean, I know in this case in particular, they sent somebody in there from a court reporting company with a mask that they're reading into Dragon Naturally Speaking, and that's becoming the official record on this thing. You know, we have some... Yeah, there's a different ways. You know, they have formal stenography where they sit down and they do the phonetic stuff, but they have this new where they actually they fit a mask over their face that it's soundproof. So as they are repeating into this mask everything that everybody says in the courtroom, and that's how they're recording testimony. Well, it's not an authorized means of recording it, and that's how they did it in this case. Yeah, and so essentially in Don's proceeding, there is no official record by rule and by law. There's a transcript of, I mean, Don, and you know, it's my opinion too, there's been no hearing, because a hearing is a term of art. There has been appearances in court, and there's been gatherings in front of court reporters and people sitting on benches, but there has been no hearing, no structured, rigid test of the evidence in a due process forum, and that's a real problem.
So why don't you go through, how many levels are there to this? Somebody filed the disciplinary action against him, which was...
Yeah, I'll explain. I'll explain. Yeah, I mean, it's actually hard. You know, one of the issues here is that judges or disciplinary authorities are unequivocally lying in many respects, but in one specific respect. Don was specifically told that there were, I think, 3 Judges Connor, Jones, and Anthony Sirica, John Sirica, Anthony Sirica. I don't get hung up on judges' names either. From the Third Circuit Court of Appeals were the complaining witnesses against him, meaning this state proceeding, by the admission of the Office of Disciplinary Counsel, was spurred on by federal judges as complaining witnesses, not disgruntled clients or anything like that. This was federal judges orchestrating this. I touched upon this whole principle earlier of what they did to the concept of federalism. You know, the federal courts and the state courts are two distinctly different jurisdictions. And the federal courts are, in many respects, their very purpose is to act as a check on abusive state processes. And typically, you know, there's case law, I mean, and legislative history behind Section 1983, that it was specifically drafted with an eye towards federal courts being a check on rogue state courts. Two completely separate spheres of influence. Well, in this case, you know, we have such a confluence between the state authorities and the federal authorities that you can't tell who's wearing which hat. Federal judges coming over to state courthouses to give testimony in state proceedings where they're the complaining witnesses. You know, they have parallel federal proceedings underway. They could, I mean, if they have a federal disciplinary process. If these judges were complaining witnesses and felt that Don was doing something wrong in federal court, and there's a lot that needs to be understood, they had procedures to do this, but they didn't. I mean, they're cowardly, and they're trying to do. I mean, it just all suggests a corrupt motive when you have federal judges who do not have the personal integrity and fortitude to enforce their own laws by saying, "Mr. Bailey, you're in violation of our rules." No, they run to the state authorities. There's a guy by the name of Paul Killian there. I don't know a lot about him, but I know enough and have seen enough to know that he's nothing but a water carrier. He's in that position because he's the kind of guy that got to that position by doing what people tell him to do, regardless of its integrity or legitimacy. And that's why he's there. And just this whole, you know, again, a lot of it is a central Pennsylvania issue because of the close connectedness between the federal judges and their old state positions. Judge Jones is a former Pennsylvania Liquor Control Board chairman. He's a former co-campaign fundraiser for Tom Ridge. Judge Yvette Kane is a former Department of State, Secretary of State for the state of Pennsylvania. She used to be with the Pennsylvania Attorney General's office. Judge Connor has his 25-year practice. I was a former colleague of Judge Connor at the firm he was a partner with. But you know, I know, you know, he probably had a little bit of federal practice back at that time, but it was largely, you know, state practice. And these guys, you know, Judge Kane, Judge Jones, you know, I remember when I worked with Judge Connor, maybe, I don't know, 3 to 5 years. I can only recall him being in trial once or twice.